Good afternoon and welcome to another in our fall series of webinars at the CMRTO. This particular webinar is entitled What You Must Know About Mandatory Reporting. My name is Tina Langua and I'm the Director of Professional Conduct and Internal Legal Counsel here at the college, and I'm delighted that you've joined me this afternoon. Sorry, I just have some technical difficulties in advancing my slides. Okay. Thank you so much. I've got technical assistance with me, thank goodness. I wanted to welcome you all here this afternoon. Our MRT members, our stenographers who are perhaps members or maybe only applicants at this point, and then anyone else who might be joining us just out of interest. If your role is manager or supervisor in addition to being a member, this information should be helpful to you in fulfilling those roles in terms of mandatory reporting. In terms of what we're going to cover today, I wanted to talk about mandatory reporting, and I thought I'd structure it in the 5 W's, or 5 W's rather, and the H, which is why, who, where, what, when, and how. And hopefully that will answer all of your questions regarding the mandatory reporting obligations you have and what the college does with mandatory reports when they receive them. We will talk about the process, what we do when we are in receipt of a mandatory report, and what you can expect if you're a reporter, or alternatively if you're the subject of a report. We'll also talk about the potential outcomes from mandatory reports and let you know where you can find out information about the numbers of reports that we deal with. We will also handle or talk a little bit about the implications of failing to make a report, because there are some implications in the legislation. Finally, we'll do a few practice questions, and hopefully I'll be able to point you to some resources if you have additional questions or require more information about this particular subject. Firstly, I want to start with a little caveat. I know that our marketing suggested that today's webinar would deal with mandatory reports and complaints, but as we prepared the presentation and material for today, we realized that that would be too much to cover in our very short period of time with you this afternoon. And so what we have decided to do is we will have a webinar at some point in the future that talks about the complaints process. And today we're really just going to focus on mandatory reports. The reason it's an important topic for us to discuss today is because the college has updated one of its pivotal pieces of communication in this area, and that is a document known as What You Must Know About Mandatory Reporting. The document was updated in October and is available from our website. And it was updated because there have been some significant changes to the legislation that have increased the mandatory reporting obligations both on members and on facilities and employers, and we want to make sure that our members are well aware of their obligations so they can fulfill those, and are also aware of what might occur if they are in fact the subject of a mandatory report. So the document, What You Must Know About Mandatory Reporting, is available from our website, as are all our professional guidance documents. You can find it under the Resources tab in Publications. So I'd encourage you, if you have additional questions, to review the document, because it does go into quite a bit more detail than I will be able to cover this afternoon. So the first thing you need to understand about mandatory reporting is that every member of our college is obliged to comply with mandatory reporting provisions. And that is because it is a standard of practice that all of our members meet professional education and registration requirements by the college, and also that they understand and adhere to the legislation governing the practice of the profession, the standards of practice, the code of ethics, and the bylaws of the college. And while that may sound like an awful lot, we're hopeful that today's webinar will break that down into digestible pieces that are easy to understand. So let's start with the why. It's always important to know why an obligation is imposed in order to understand the rest of it. Before the mechanics and the process, we need to understand the rationale and the purpose of mandatory reporting within a self-regulation scheme. So firstly, we have to go to the mission and why regulators exist. The College of Medical Radiation Technologists, like all the other 25 health colleges under the Regulated Health Professions Act, exist to serve and protect the public interest. And so that means all of our specialties are regulated with that focus in mind. And so mandatory reporting is actually a pivotal piece of public protection in terms of how it fits. The college has a specific statutory duty to serve and protect the public interest. And that's true not only of the CMRTO, but as I mentioned, of all 25 health regulatory colleges have the same stated purpose. In fulfilling our role as a regulator in the public interest, there are a number of forms of regulation the college relies on. 3, in fact. There is restrictive regulation, proactive regulation, and reactive regulation. When we talk about restrictive regulation, we mean only allowing people who have the appropriate qualifications to actually become registered to practice the profession. So that's our registration processes. When we talk about proactive, it's about ensuring that members of the profession remain competent throughout their career, particularly in a profession such as yours, which has immense technological evolution and change over time. Finally, we have the reactive form of regulation, and that deals with the information that comes to the college's attention about the conduct of its members. And that might come in the form of a complaint or a mandatory report. But it really is an important obligation that the college react to the information appropriately and deal with the information in a way that serves and protects the public interest. And that is why the legislation contains provisions to ensure that the college obtains the information it would need in order to govern its members in the public interest. There are several places where mandatory obligations are set out. The first, of course, is in the Regulated Health Professions Act, or as we like to call it, the RHPA. The RHPA applies again to 28 health professions regulated by 26 colleges in the province. So your requirements as a member of the CMRTO are no different than the requirements that are imposed on other professions governed by the same piece of legislation. So the Regulated Health Professions Act has a number of reporting obligations that it imposes. Because they're imposed by statute, we refer to them as mandatory reporting requirements. They are not optional. The legislation requires members to actually comply with these provisions. So the first set of reporting obligations are those that are put on members. And we'll talk specifically about what information members are required to report to the college. The second very large category of reporting is reporting suspected sexual abuse. And that is a requirement that is imposed not only on all members, but also on employers and facilities. And then there are separate reporting obligations that are imposed on employers and facilities. Again, all of these obligations are meant to ensure that the college as a regulator receives the information it needs and responds appropriately in order to protect the public of Ontario. It would be nice if there was only one piece of legislation that imposed mandatory reporting obligations, but unfortunately that's not the case. As a regulated health professional, members of the CMRTO are also have mandatory reporting obligations pursuant to the Child, Youth and Family Services Act. And that particular piece of legislation requires our members to report if they are aware of a child that is in need of protection. In addition, the Personal Health Information Privacy Act also imposes some mandatory reporting obligations on facilities and employers if they are what's known as a health information custodian. In other words, if they maintain, collect, or record personal health information, they are required to make mandatory reports if there are privacy breaches within their facility. So that's an additional piece of legislation that our members need to be aware of. So now let's talk about the who. Who exactly has mandatory reporting obligations imposed on them by these pieces of legislation? There really are three groups. First of all, members of all 26 regulated health professions do have mandatory reporting obligations that are imposed on them by the Regulated Health Professions Act and by the Child, Youth and Family Services Act. In addition, there are separate mandatory reporting obligations for employers of regulated health professions. and also facilities where regulated health professionals are employed. I can't speak to why employers and facilities are dealt with differently. That just happens to be how the legislation evolved, but there are slightly different obligations imposed on the two groups. So we will talk about the difference and what those obligations are. So moving on to the what is required to be reported. What's required to be reported under the legislation differs depending upon who the reporting obligation is imposed on. So let's start with members. That's the biggest group of individuals who have reporting obligations under the legislation. So members of the CMRTO have an obligation to report certain information to the college as it happens. So if members are ever, if a finding of professional negligence or malpractice, as it's sometimes called, are made against a member, that's something that a member is required to report to the college. That doesn't mean that you've been named in a lawsuit, but rather that a lawsuit has made its way through civil court and a decision has been issued that imposes that finds negligence against you as a member. So that we don't have a great deal of those types of cases, but it certainly is possible, and there are other health professionals that are more affected by that particular requirement. A new change to the legislation is the requirement that our members report not only offenses, so findings of guilt related to offenses, but now there's a requirement that members also report charges. So charges would be if a member is charged with a criminal offense, that would be reportable to the college. There's also a requirement that any bail restrictions or conditions that may have been imposed upon the member for their release into the community also be reported to the college. The types of bail conditions and that are often put in place after criminal charges is that individuals not contact the victim. There may be restrictions on their ability to practice within a medical or healthcare setting. There may be restrictions on the kinds of patients that they're able to be exposed to. There may be restrictions that require them to be chaperoned in their practice until such time as the criminal charges are dealt with. So you can see that it would be important for the college to be made aware of this information and important that it be posted on the public register for both employers who may not be aware and also for patients. It's all the transparency of information that regulated professionals are required to make available to the public so that they can make informed choices about who they go to for their health care. In addition, there's a new requirement that requires our members to let the college know if they are registered in another jurisdiction. So perhaps they're registered as an MRT in another province or a state in the United States, or if they are registered as a different healthcare professional. So for instance, if someone is also registered as a respiratory therapist, there is an expectation that the college would be made aware of that registration. And so it's not only the fact that you belong to another regulated health profession that's important for the college to know, but members are also required to disclose if there's ever been a finding made against them by that other regulatory body. And by a finding, we mean a finding after a hearing process where the individual has either been found to have engaged in professional misconduct or has been found incompetent or perhaps incapacitated. Because labor mobility across the country has been made quite a bit easier, it's important that every jurisdiction be aware of what may have occurred in another jurisdiction. So that's the logic behind members being required to report their registrations in other jurisdictions and any findings as well. In addition, members have an important mandatory reporting obligation around sexual abuse. The Regulated Health Professions Act has long had many provisions specifically aimed at ensuring the reporting of sexual abuse and eradicating sexual abuse of patients by members. And so again, these provisions apply to all healthcare professionals that are regulated under the Regulated Health Professions Act. And specifically, the requirement is that a member of the CMRTO must report suspected sexual abuse if, and there's a bit of a checklist we need to go through. So first, they have to have reasonable and probable grounds. There are entire courses at law school taught about reasonable and probable grounds, so difficult to convey it in this type of a presentation. But if the information comes to you directly from a patient, that certainly meets the threshold of reasonable and probable grounds. So you would have to consider the source of the information, etc. This reporting obligation applies only to information obtained in your practice, so not when you're at the bar on a Saturday night or having a dinner party with neighbors. The obligation is specific to your practice. And if you have obtained information that a patient may have been sexually abused by an identified health professional. So a couple of things that are important in that phrase, and that is that it's any health professional, not just another member of the CMRTO, but a member of the College of Physicians and Surgeons, a College of Massage Therapists, any of the regulated health professions. If a patient discloses to you that they have been sexually abused by another health professional, this mandatory obligation, reporting obligation is triggered, and you are required to make a report. So what are members required to do if in fact they find themselves in that situation? The report they make has to be in writing. It has to be made to the health professional who is alleged to have abused the patient, to that health professional's college. So if the allegation is that a massage therapist has abused a patient, then that report would be made to the College of Massage Therapists. Equally, if any health professional came to information that one of our members had sexually abused a patient, that report, their reporting requirement would be to the CMRTO. And then it's the regulatory body that determines the next steps in the investigation and the process. But the important piece is that the information get to the college's attention. It's important also to note for our members that the report can only include the name of the patient if they have the patient's consent in writing to their name being disclosed. So a couple of things. First of all, if you don't know the identity of the health professional in question, so the patient has shared that they have been sexually abused, but they are not willing to provide you with the name of the individual and you're not able to ascertain it, there's no reporting obligation because you don't have sufficient information to share. However, if you do have the name or identity of a healthcare professional or you're able to discern it, then you have an obligation to make the report to the college. However, you cannot include the patient's name in that written report unless you have their written permission to do so. You may wonder, well, of what use is a report which doesn't contain the patient's name? In the area of sexual abuse, there tends to be more than one victim, and the college may be in receipt of other reports regarding this member. And so it's really important that that information be provided, even in the absence of the patient's name. It's important to put the patient at the center of the report in the sense that if they are not comfortable with their name being shared, that's to be respected. There is no need for you to dig or coerce or try and cajole someone into that choice. That should entirely be that patient's choice, and they should determine whether they're comfortable with that. You may find, if a report is made to the college about potential sexual abuse, either by the police or by a member, and we don't have the patient's name or permission to disclose it, we might send along some information to the reporting member and ask that they share that with the patient. And the information would just talk about what the college's role is, how we can assist them, how they can access our processes. Again, respecting the fact that it is the patient's choice to decide whether or not they wish to proceed with the report or have their name included, but at least providing them with some background information about what the college is all about, and the fact that we exist for the protection of the public. So I guess I would categorize member mandatory reporting as falling into two categories. One would be self-reports about charges, convictions, findings of negligence, etc. So that's self-disclosure, and then an ongoing obligation to report if they ever come in, if they ever obtain information that a patient may have been sexually abused by a healthcare professional. What about employers? What kinds of mandatory reporting do they have to do as in their role? So employers have an obligation to report to a college if they terminate a member, or if they intended to terminate the member, but the member quit before they were able to terminate them. And they're also required to report if they impose a suspension on a member, and that's a suspension of any length of time, be that 1 day, 5 days, whatever the case may be. A suspension triggers a mandatory report to the college. Employers have to report if they restrict a member's privileges. A couple examples of that might be that an individual is no longer permitted to work in a particular area, like CT, for instance, or they're no longer able to work alone at night. So there's all kinds of those restrictions, and if those are imposed by an employer, those are reportable to the college. Also, if an employer dissolves a partnership, a professional corporation, or an association with the member. But all of those things are reportable only if the reason for the termination, suspension, restriction, etc., were for reasons of professional misconduct, incompetence, or incapacity. And one of the big reasons why mandatory reporting obligations were included in the Regulated Health Professions Act is when a member is terminated from one particular facility or employer, that employer may feel like they've done a great job at protecting the public because that individual is no longer practicing in their setting. However, that member still has an unrestricted certificate of registration. So it's important that the college be aware of the termination in order that they conduct appropriate investigations and inquiries to ensure that the member doesn't just go to another employer and repeat the same conduct. And so that is really why mandatory reporting becomes an important source of information for regulators. You might wonder why the threshold for mandatory reporting is a suspension. So you'll notice that letters of warning and letters of reprimand and things of that nature are not included. And that is because health regulatory colleges do not want to become the HR department of the healthcare system. And it's recognized that there is all kinds of progressive discipline and progressive performance improvement that is done in a workplace that is completely appropriate and does not require the college to be involved. However, when someone has gotten to the point where an employer is suspending them, restricting them, or terminating them, there may be a larger problem afoot. And that's why that's the threshold at which the college has to receive a report from the employer. A little bit different requirements on facilities. Again, I'm not even sure what the difference is between an employer and a facility. In some cases, I think it would be the same entity. So facilities are required to report if they have a member in their employ who they believe is incompetent or incapacitated. So this is in the absence of imposing any kind of discipline on a member or suspending or restricting. But if they believe they have someone in their employ who's incompetent or incapacitated, it necessitates a report to the college. This would cover situations where an individual perhaps is on medical leave, but is still employed in the facility. Important to let the college know, not that the college would necessarily intervene, but it's important that the college be aware. Because remember, that member may be restricted from working in your facility or be working in your facility, but they could also be working in a number of other facilities. And so it's important that that information about incompetence or incapacity gets elevated to the regulator who can do something about it. In addition, facilities, any facility that's a health information custodian, and remember that's any facility that collects or records personal health information, which would essentially be pretty much every employment site where our members are practicing, are required to report to the college if they take any disciplinary action against a member due to unauthorized collection, use, disclosure, retention, or disposal of personal health information. So those are privacy breaches. And so while a letter of warning for professional misconduct wouldn't trigger a mandatory report, if the professional misconduct involved a privacy breach, then this particular clause would kick in and the health information custodian would have to report that fact to the member's college, and in fact would also have to report it to the Privacy Commissioner's office in Ontario. So in order to understand what needs to be reported, it's important to understand what the terms professional misconduct, incompetence, and incapacity mean, because that's often the struggle people have, is does this fit the reporting requirements? Is it professional misconduct? Is it incompetence? What does that look like? So taking each term in turn, professional misconduct, incompetence, and incapacity are all defined by the legislation very specifically. Professional misconduct is defined as being guilty of an offense relevant to the member's suitability to practice. So that might also be a criminal offense. Being guilty of an offense in another jurisdiction, if someone is registered in another jurisdiction, and again, remember that's something that members have to report. Failing to cooperate with the QA committee is a specifically enumerated ground of professional misconduct in the legislation. So important that you recognize that quality assurance is not only a valuable program to ensure continuing competence, but it's a mandatory program that all members have to engage in. Sexual abuse, as I mentioned earlier, is very specifically defined and dealt with in the Regulated Health Professions Act, and it is professional misconduct to sexually abuse a patient. However, those aren't the categories that are the most common. Most common we see is that it's professional misconduct as defined by the Professional Misconduct Regulation. The Professional Misconduct Regulation is made under the Medical Radiation Technology Act. And it lists all kinds of conduct that amount to professional misconduct in our profession. And the most common that we see mandatory reports emerging from are a failure to maintain the standards of practice, specifically because our standards of practice require our members to comply with facility policy. So failure to comply with facility policy is failure to maintain the standards of practice. And if someone's suspended because of that failure, it would trigger a mandatory report to the college. There are about 35 grounds of professional misconduct articulated in that regulation, and they run the gamut from signing a false document, verbally abusing a patient. There's a whole list of things, but by far the most common ground that we see in a mandatory report is that someone has failed to maintain the standards of practice of the profession. So it's important that you be aware of what those standards are, because failing to maintain those standards is professional misconduct. There's another basket clause in the Professional Misconduct Regulation that says it is professional misconduct for a member to engage in conduct that, having regard to the circumstances, other members would find disgraceful, dishonorable, or unprofessional. And that is because while there was an attempt to list all the bad behavior that is professional misconduct, you need to have a clause to catch conduct that perhaps wasn't contemplated or isn't specifically spelled out in the regulation. So that's sort of our basket clause that is often a common ground for reporting as well. So moving on to incompetence. Incompetence is defined in the legislation as a lack of professional care of a patient that displays a lack of knowledge, skill, or judgment of a nature or to an extent that demonstrates that their members unfit to continue to practice or that their practice should be restricted. So as you can see, incompetence is a somewhat higher bar than professional misconduct, and it really talks about a pattern of behavior, the person's entire practice. We're not talking about one incident or one error or a one-off. We're talking about more than that, that there's a lack of knowledge, skill, and judgment that makes it essentially unsafe for this individual to continue to practice. So we admittedly do not see many reports of incompetence. College has received some in its history, but by far the most common mandatory report is hooked to professional misconduct. And then finally, incapacity. Incapacity is when a member suffers from a physical or mental condition that makes it desirable in the interest of the public that that member be subject to terms, conditions, or limitations, which really is restrictions on their practice, or that they no longer be permitted to practice. So when we talk about incapacity, we're talking about health. We're talking about well-being. We're talking about a member suffering from a condition or disorder that is interfering with their ability to practice safely. Obviously, as a regulator, that's incredibly important, as our goal and role is to ensure public protection. And so that's why health-related matters are specifically caught in the mandatory reporting obligations as well. Now we'll talk about when reports need to be made. Some of them are in fact quite time limited, so it's important that people recognize that when a mandatory report is triggered, they only have a certain amount of time within which to file that report with the college in order to be in compliance with the legislation. So it breaks down a bit like this. All the members' self-reports, so those are convictions, bail conditions, charges, negligence findings, those all have to be filed immediately. So when the member becomes aware of them, and believe me, if you're found guilty of a criminal offense, you're aware, the member is required to file that report immediately with the college as soon as they become aware of the issue. The same is not true for suspected sexual abuse, the employer reports, or the facility reports. In those cases, the legislation says that there's 30 days to make those reports. That's the time limit that's imposed. But there is a caveat, and that caveat is to say that if an individual who's required to report believes that the sexual abuse will continue of the same patient or other patients, or the reporter believes that the member has a potential to harm or injure a patient and urgent intervention is needed, then the report must be filed immediately. So there is an aspect of determining the level of risk associated with the report to ensure that you make it quicker than 30 days if there is an urgency related to patient safety. So where do these mandatory reports emerge? Not surprisingly, the vast majority of the mandatory reporting obligations, both on members and employers and facilities, relate back to an individual's place of practice. But there is one notable exception, and that's what I mentioned earlier. The Child, Youth and Family Services Act requires that all regulated health professionals make reports of a child being in need of protection, regardless of where they may come by that information. So that means it extends to your personal life. It includes the grocery store, the cocktail party, the dinner party, and your day-to-day observations. You know, we pick up our kids at school, we drop them off at school, they play with other children, etc. So in that sense, everyone is required to report regardless of where they come by the information. And those reports, by the way, I should have mentioned earlier, are made to the local Children's Aid Society. So we've covered all our W's. We know why we make the reports, who has to report, what has to be reported, where the reports emerge from, and when. Now we're going to talk a little bit about how. So what does mandatory reporting look like, and what happens when the college receives a mandatory report? So the first thing that members need to understand is that when CMRTO receives a mandatory report from employers or facilities, and those are by far the most common mandatory reports we receive, the first thing we do is request all the documentation related to the internal investigation conducted by the facility, so that we have all the background information that was in place when the employer made the decision to suspend or terminate, for example. And then simultaneously with the request for additional information from the facility, we also notify the member that we have received a mandatory report, and we request the member's response and submissions. And that is because the process has to ensure fairness to all involved, and it would be completely unfair for the college to conduct an investigation behind the scenes that the member was not aware of. It would also be completely unfair to proceed to make a decision without having the member's input. The member has a right to be heard. If allegations are made against them, they have a right to make submissions. And so that's why our process starts at that point, and we request the information from both sides. Upon receipt of the information, both from the facility and from the member, the registrar reviews the information, and it is the registrar that determines what the appropriate next steps might be. So what should you know? What are the do's and don'ts of responding to a mandatory report? First of all, it is, and we recognize, very stressful to receive notification from your regulator that a mandatory report has been filed. When I talk to employers about their mandatory reporting obligations, I always encourage them to disclose to their employees that they are required to make a report, because then it comes as less of a surprise when the college contacts the member for their submissions. I also counsel employers to give employees my name and contact information so that if an individual needs guidance or assistance through the process, they know who to contact and they know who to call. But when somebody is responding to a mandatory report, there are some high-level do's and don'ts that are going to make the process a lot easier. First of all, please provide as much information as possible. Recognize that each of your places of practice are very distinct. They have unique cultures, they have unique environments, they have unique pressures. And so it's important that you convey, because all of this is reviewed in writing, it's important that you convey anything that's important contextually in your response. Perhaps there's, is it a busy location? Is it not a busy location? What kinds of supports are in place? What else was going on at the time? Is there anything else that the registrar should know about the particular incident that wouldn't be apparent unless you let them know? This is your opportunity to give your side of the story. Oftentimes we are contacted by members who say, I don't really know what to say. I'm not sure how to respond. In addition to responding to the particular incident that may have led to a suspension or termination, it's also important for you to let us know what your normal practice is. This may have been an incident that went badly and is a one-off and is very different from how you would normally handle your practice or your patient interactions. And it's important for us to hear from you about what your normal practice is. So please include that as part of the response. It's important for members to accept responsibility for their actions. We recognize that healthcare professionals do not go to work with the intention of harming or doing any wrong. They go to work with the intention of doing their very, very best. And sometimes, for circumstances beyond our control or perhaps human error, things happen that perhaps are not the best and that we would like to redo or do differently were they to happen again. It is an important part of being a regulated health professional, and it's an important part of being a self-regulating professional to be able to reflect on the incident and accept responsibility for those areas where perhaps your practice was not at the level that you would expect it to be. It's also helps immensely if you can demonstrate in your response that you've reflected on how you could possibly improve in the future. So maybe an interaction with a patient went off the rails, there was some communication issue, but upon reflection, you have identified some strategies, some scripting, some wording that could actually improve an encounter in the future and would ensure that this type of thing wouldn't happen again. That type of insight is critical for professionals. It's a cornerstone of being a professional, that you're able to be reflective and have insight into your own conduct and how it might be improved. So that's important for you to include, to let the registrar know that you have recognized there are things that could have been done differently. Make sure you review any relevant standards of practice and your own facility policies, because as I mentioned before, the college asks for the facility to provide all the documentation, including any relevant policies and procedures. So make sure you review those policies, and maybe when you review the policy, you will reflect and realize you missed a step or you weren't in strict compliance with the policy. It's a great idea to just point that out. I've now had an opportunity to review the policy, and I recognize that my practice on that day was not in accordance with the facility policies. And going forward, this is how I plan to do it in the future. That's the type of response that's really helpful, because it not only provides your side of the story, if you will, it also gives the context of the practice environment in which the incident happened, and it allows the registrar some insight into how you've reflected on the incident and what might be done differently. Along with a list of do's, there is almost always a list of don'ts. So let's talk about the don'ts. First of all, don't worry. And I know it's easy for me to say sitting here, not being the subject of a mandatory report, not to worry, but members are understandably distressed by having received a mandatory report. We do not have many in a year, 19, 20, and when you consider we're going to be an organization of close to 11, maybe 12,000 members, and how many procedures our members are involved in every year, that is a tiny, tiny portion. So don't worry, there is a process. The process that's in place is there to ensure that you're heard from. We don't proceed without having your submissions. The process is also multi-step. So often members will call and say, am I still allowed to work? Absolutely. Just because a mandatory report is made and an investigation may be going on, it doesn't affect your status, your ability to work as a professional. You can continue to do that. The college does not have the power to take away your certificate of registration just because we got a mandatory report. That would be patently unfair. There is a number of steps in the process that need to be gone through before that decision can be made. And the other thing you need to know is those decisions are never made by staff. They're made by panels made up of your colleagues and peers and representatives from the public. So don't worry. And please reach out for help. It is a distressing time. You want to know how best to address this. And that's what staff is here for. We're here to assist members and guide them through the process. We can't tell you what to say, but we can certainly help you in terms of understanding what the registrar is looking for and what information you might want to think about looking at or including. Don't forget that reporting is mandatory. Don't take personally the fact that your employer not only suspended you for something, but to add insult to injury decided to report, because that's not the case. Your employer has no choice in the matter. If your employer decided for whatever reason they weren't going to report that suspension, they would be in breach of the legislation and they would potentially be subject to quite large fines. So again, this is not an optional choice for your employer. Your employer has to report. And again, I encourage employers to advise members right up front when this is happening if a mandatory report is going to be required. Don't point fingers or blame others. We all recognize that there are many people involved in healthcare settings and that there may be shortcomings in other places, but that's not the focus. The college regulates its members. It doesn't regulate facilities. It doesn't have the authority to impose better policies or different policies, etc. We really are just looking for a response from you as the member, what your role was. And it's most helpful to just keep that focus on your practice and the steps that you took and what you might change in the future. Don't ignore facility policies and standards, because those are the things that will guide the decision making that the registrar makes. She will look at the policy and see if the conduct that's being reported is in compliance with that policy. So it's important you understand those so that your response is in keeping with that. And please don't miss the opportunity to reflect on and improve your professional practice. No one is perfect. We are all human. We can all do better. We can all learn. And if you can approach a mandatory report from that perspective, it will be much less stressful. And you will also find that the outcome is probably more favorable because you've demonstrated that you understand whatever issue may have led to your suspension or termination. So just a few tips. So in terms of the registrar's decision making, the registrar is the one who decides what next steps, if any, will take place. She bases it on reasonable and probable grounds, and of course the documentation and information she has before her. If she needs more information or requires clarification, then she might direct staff to contact you to get some additional contextual information or responses to specific questions. But once that information is all there, the registrar bases her decision on risk. So because we're a public protection body, the higher the risk to the public of the conduct reported, the more likely that's going to lead to a next step. The lower the risk, there may be other options the registrar is willing to entertain. It might also depend on what the employer reports. It's not uncommon for us to get a report. Privacy breach is a good example of someone who has not complied with the privacy policies of their facility. They've been through an investigation internally. The facility has assigned a number of remediative steps to the member. The member has taken those steps. And sometimes the employer report comes to us and actually says it's our position that no further action needs to be taken. So it will very much depend on the particular situation, the fact situation, and the evidence we have in front of us. But the decision the registrar makes is always based on risk. And in addition to risk, she will always take into account aggravating and mitigating factors. So an aggravating factor is a lack of insight. A mitigating factor is insight. So back to the do's and don'ts of responding to a mandatory report. It will mitigate the risk if you demonstrate that you are aware of what went wrong and that you know what not to do or what to do in the future. So those are the factors that the registrar takes into consideration. The registrar has another number of options available to her in terms of how she deals with a mandatory report. So she might decide to conclude the matter with no further action, either because she feels that the member has been sufficiently remediated through the workplace, has demonstrated insight, and that she feels there's no further action that needs to be taken. The matter can now be concluded. So that's, in fact, that is a large part of how our cases are resolved. The registrar might conclude a matter with reminders to the member. So in other words, a reminder might be, I've taken into account the investigation and your response, and I'm concerned that you weren't complying with facility policy. So there might be a reminder that the standards of practice require our members to comply with facility policies. Obviously, concluding with no further action or concluding with reminders is reserved for the lower risk types of conduct that are reported. Other tools the registrar has available to her is to ask that the member sign an appropriate acknowledgement and undertaking. And that might be, it's a formal contract between the member and the college. The member acknowledges their conduct. They acknowledge that it fell below the standards of practice. They agree to comply in the future. And there might be components such as agreeing to complete jurisprudence or agreeing to read the standards again or whatever is appropriate in the case. But that's essentially an informal resolution whereby the member and the college enter into an agreement to resolve the matter, and it need go no further because the member has agreed to sign that acknowledgement and undertaking. And that can be used in situations of low and moderate risk. Now, moderate and high risk matters also might be referred to the Inquiries, Complaints, and Reports Committee, which is what ICRC stands for. My apologies for the alphabet soup. So the registrar can ask that the Inquiries, Complaints, and Reports Committee approve the appointment of an investigator to investigate the incident in question, at which point it goes out of the registrar's hands and into the ICRC's hands. So now it is in a committee process. And we will discuss what that looks like when we have our future webinar about complaints, because it's the same process for both. If the registrar believes that there are health matters that are raised by the mandatory report, so concerns that the member may be incapacitated, then the registrar can also refer that matter to the Inquiries, Complaints, and Reports Committee and ask that an inquiry panel be appointed. Inquiry panels are specifically aimed at making inquiries into a member's health and their fitness to practice. So that's the range of outcomes that the registrar has available to her. If you're wondering how many complaints do we get, how many mandatory reports do we get, how are they dealt with, the best source of that information is the college's annual reports that are available from the website and would list in professional conduct the actual numbers of cases that the college deals with each year. And I can tell you that given the number of members and the number of procedures, it's quite small. So that's encouraging, both for ourselves as a regulator, and I hope encouraging to you as members, that this is not a huge component of what the college engages in terms of its work. Just to dispel a few myths, because I'm aware that there are some myths that float out there around mandatory reporting. A mandatory report is not a complaint. It's not optional, but it is not a complaint. So back to not taking it personally, your employer does not have any choice in the matter. It's not that they don't like you or they like someone more than you. They have an obligation to make the report. And so it's important to keep that in mind, because you may require some assistance from folks at your employer facility in responding to it. And so we don't want to set up an us against them sort of situation. The mandatory report is meant as a component of public protection in self-regulation, and it's not optional. So that's the first thing that I need to dispel. Secondly, we have heard situations, or I have in my travels from college to college, where employers threaten the member and say, I'm going to report you to the college and you're going to have your license suspended immediately. Well, they may be intending to report, and they may be required to report, but there is no such thing as immediate suspension or revocation of your certificate of registration. Just because a report is made does not mean your ability to work is compromised in any way. What the report does is trigger a process that you will be involved in every step of the way. Nothing happens without you being informed and you being aware. So that's an important thing to keep in mind. Mandatory reports are confidential, and the investigation of mandatory reports are confidential, and that includes even if they go to the Inquiries, Complaints, and Reports Committee. These issues are not noted on the public register. There's no notation, there's no restriction on your ability to practice. The only people who can do that are committees of the college. Again, staff does not have the authority to do that. And the committees are made up of both MRTs, diagnostic medical sonographers, and representatives of the public, because that's the self in self-regulation. You should be judged by your peers, and that is why those decisions that might impact someone's ability to practice are only made by committees or panels. Members are always advised when a mandatory report is received, and they are always given an opportunity to make submissions. The same is true of complaints. I have had individuals call me and ask if there is a report against them or if there's a complaint against them. And what I tell them invariably is, if there is, you will be the first to know, because that is the beginning of our process. And on the complaint side, we're required to notify a member of a complaint within a certain time limit. So again, the processes are fair. They're meant to be fair and objective and impartial, and they're meant to give a member an opportunity to be heard. What are the implications of not reporting? The legislation imposes some pretty serious fines on individuals for not reporting. And the reason there's fines in the legislation is because some people who have reporting obligations are not members. So for instance, some employers are not members, facilities are not members. Your facility might not be run by a member, might be run by someone else, an administrator, another health professional. And so it's important that if a facility or employer fails to make a report, there be an ability for the college to pursue that through provincial offenses court and have fines imposed by that court. So for members failing to make mandatory reports, there's also professional misconduct implications. So failing to make a mandatory report is a failure to comply with the legislation, and it is also a failure to maintain the standards of practice. And so those are the implications for failing to make a report. So moving on to a couple of quick practice questions before we wrap up. So first practice question, Mark, a medical radiation technologist who works at Anytown General Hospital, was issued a letter of warning because he viewed his wife's x-rays when he was not part of her circle of care. So does Anytown General Hospital have a mandatory reporting obligation to the CMRTO? So the answer is yes, and regardless of the fact that Mark only received a letter of warning, wasn't suspended, wasn't terminated, wasn't restricted, the Personal Health Information Privacy Act requires that Anytime General Hospital report any disciplinary action taken against a member for a privacy breach. That has to be reported to the college. So in that case, there would be a mandatory report to the CMRTO from Anytime General Hospital. So our next practice question, let's move to another specialty. So Sandra, a diagnostic medical sonographer that works at Anytown Ultrasound Clinic, was issued a one-day suspension as a result of her failure to follow clinic policies regarding infection control. So does Anytown Ultrasound Clinic have a mandatory reporting obligation to the CMRTO? And the answer is yes. Employers are required to report suspensions of any length of time for, as we mentioned earlier, professional misconduct, incompetence, or incapacity. In this case, the professional misconduct would be failure to follow clinic policies. So that what is professional misconduct? So that means that the clinic must file a written report with the registrar of the CMRTO. So where do you go if you need more information or want more information about these subjects? The best source of information is our website, www.cmrto.org. There is a number of publications available from the website. I would encourage you to access the What You Must Know About Mandatory Reporting and read through it. It does go into more detail in the topics that we've been discussing this afternoon. But there's also access to all other kinds of resources from the college, including other What You Must Know About documents that cover important topics. The standards of practice are there, the code of ethics, the legislation, the bylaws. It's one-stop shopping in terms of information. So I would encourage you to visit regularly and to make sure you're aware of what resources are available to you. One particular resource that I would encourage everyone to make use of is the CMRTO Practice Essentials. It is a one spot where you can find everything you're going to need to know about a whole lot of topics, including legislation and regulations. And it's downloadable as an ebook. So for those of you who have insomnia, need some late night reading, this might be a good place to go, but it's also downloadable on devices. So if this is information that you want to have with you and you don't have access to a computer in your workplace, this is a way that you can access that information. This is always maintained and current. Important to note, the legislation does change, so you need to be aware of those changes as they come on and how they affect you as a practicing professional. Another great place for information is the college's jurisprudence course. It is a 7-module learning package that members have access to through the member portal. The members can also access a quiz that will allow you to test your knowledge. This is a fabulous way to learn about all the regulatory responsibilities you have. Also a fabulous way to get more professional activities for your QA portfolio. So spending time on the website reviewing the college's documents certainly counts as time towards your professional portfolio hours. Don't hesitate to contact us. That's what we're here for. I've given you photos here of myself and you recognize me from the screen, but these are my colleagues, Sophia Rose and Elizabeth Urso. If you have any questions about whether or not something should trigger a mandatory report, what the mandatory report should look like, any of the mandatory reporting obligations, if you need guidance through the process, if you've received a letter from the college and you don't understand what it means, please don't hesitate to reach out and call us. That is what we're here for, and we'd be happy to help you in any way we can. I'd also encourage all of our members, applicants, and other interested parties to make sure that they keep in touch with what's new at the college. Again, legislation changes, things happen quickly, more quickly now than they used to in the past, and so it's important to keep up to date and regularly review what's coming up. Also, as we dip our toe into the world of webinars, this is another great opportunity for members to include hours viewing webinars as part of their QA portfolio as well. And so that you know, for those folks who haven't been able to attend in person today, all of our webinars are posted on the website, so you should be able to access them at any time and view them in the comfort of your home. So just a little review of what we covered today. We recovered the 5 Ys and 1 H of mandatory reporting, all of which are covered in greater detail in the new document, What You Must Know About Mandatory Reporting, that is available from the website. Talked about a few practice questions. If there are other practice questions you have in mind or hypotheticals you want to run by us, please don't hesitate to give us a call. We're happy to talk you through that. And then we talked about where you might find some additional resources to assist you and guide you as you go through this process. So a few little things that we would ask that all of our members and potential members and applicants do, and that is review the practice essentials. Read your email. The college now communicates primarily with members through email. All members have an obligation to have a unique email that they check regularly for college communication. So if you have not updated your member profile lately, and you're concerned that perhaps we don't have the most current email for you, please go in and have a look and make sure that that is current. And also be sure that it's an email that you regularly check, because the notifications will go to you directly. You can follow the CMRTO on social media, which means that you wouldn't have to check that website every day. You get notifications pushed through to you when something is new, so that's important. Tell your colleagues about the resources available, the social media feeds, the website, all of those things. Information is power, and so it's important that as many people as possible have access to all that information. Although the deadline for applying, or the administrative deadline for applying to register as a diagnostic medical sonographer, was November 16th, which was last week, if you have not applied, I would encourage you to apply immediately. The registration requirements will change dramatically effective January 1st, 2019. And if your application is not into the college prior to that, there will be very different requirements that you will have to meet in order to be registered. And then for those applicants who have been approved for registration, first of all, congratulations. We look forward to welcoming you to the fold, but we would encourage you to register no later than early December so that your name is on the public register and so that you can provide, that you can demonstrate that you're eligible to practice a diagnostic medical sonography effective January 1st, 2019. Thank you all so much for taking time this afternoon to join us, and we look forward to covering other topics with you in the future.